Everyone, thank you for joining us today. Today is the third in our series of webinars for advocates on child custody topics. We've had two prior webinars, one on an introduction to family court and one on helping clients to present their evidence better. Recordings of those webinars are available on our website, which is under the web links box. Today we have the Legal Resource Center on Violence Against Women, Deb Goelman and Sarah Whitesell, here to talk about interstate custody issues that arise in domestic violence cases. And we're very, very glad to have them. Just before I turn the webinar over to them, briefly, just to provide a little bit of background and some guidance on, we're going to be talking a lot about legal information today regarding interstate custody and jurisdiction. When a non-lawyer is talking to a client about these issues, there always has to be in the back of your mind this distinction between legal information and legal advice. Legal information is just information that you may have about the legal system or the law, court rules, procedures, any other type of information. And it can be gained in a lot of ways. Lawyers get it by going to law school and then by practicing. Court staff get it by working in the court system. You as advocates likely have some from your interactions with the court system on behalf of clients or with clients providing support. And then just anybody who happens to have a court case will get some information by their experience in having their own court case. Legal advice is when someone who has training is providing, is not just having their legal information, they are applying it to the facts of a particular client's case. And there's some examples here kind of help to draw the distinction. Legal information is telling somebody these are child custody forms for our court, or here is the form for requesting an exemption from mediation. Here is the number to call to ask for a hearing in your case. You can outline options that are available. We have mediation at our court. We have early neutral evaluation, and here's how you go about picking one. Legal advice is guiding the client, telling them this is the form you should file and here's what you should write. Here are your options and this is the one you should pick. You should request an exemption from mediation or you should not request an exemption from mediation. When you're specifically guiding the client, that is when you cross the line into legal advice, and that's what you need to be careful of. If you're just saying this is what happens or this is the form for this type of case without specifically telling the client which form to use or what to write, then that's legal information. Today we have the Deb and Sarah from the Legal Resource Center on Violence Against Women, and I'm going to turn this over to them.
Thank you so much. Good morning. I'm Sarah Whitesell, Co-Executive Director here at the Legal Resource Center on Violence Against Women, and I'm here today with Deborah Goelman, my Co-Executive Director, and Amy Lewis, our Project Coordinator in the office. Thanks so much for joining us this morning for our webinar on interstate custody and domestic violence issues, and thanks for all you do every day to help domestic violence survivors. And finally, I'd like to say a huge thank you to the team at NCJ-FCJ for hosting and co-sponsoring this webinar this morning and for providing that background. We have two objectives really today. The first is to introduce you to the LRC and the work we do, and the second is to provide you with some basic information on the laws involved when survivors relocate across state lines with their children. We know that as advocates you get a lot of questions about that. We'll break about halfway through for some questions and answers. We'll try to keep an eye on questions that might arise during the presentation, but we make no promises there. We're happy to address the questions at the midpoint, and also, of course, if you want to follow up with questions, in particular questions about particular cases or factual issues, please do. You have our direct number. First of all, we're interested in doing a quick poll on how many of you have ever heard of the LRC. You can click to the right of the slide to let us know. We basically can help with interstate custody issues involving domestic violence. We have a hotline, and that number is on the second to last slide. We talk by phone every day with professionals across the country who have questions on the UCCJEA, which we'll talk about today, the Uniform Child Custody Jurisdiction and Enforcement Act, and related statutes. We talk to attorneys, advocates, and court personnel. We provide sample pleadings in case law, and we help strategize about cases. In terms of written resources, we have a website with state versions of the UCCJEA and related laws. We're currently updating the relocation laws that are on our website, but you can definitely use what we have as a starting point, and we'll soon have more completely up-to-date sites. We've also produced case law summaries and checklists that are aimed at attorneys, advocates, and survivors, respectively. And we've included the advocate and the survivor checklist in the materials on the webinar. We're happy to provide the other materials to you if you'd like them. And please note also that the survivor checklist is also available in Spanish. For survivors who call us on this hotline, when there's a jurisdictional question, we can help them find an attorney by using our database of attorneys and programs across the country. So please feel free to refer your clients to us directly if the case involves more than one state or tribal jurisdiction, domestic violence, and custody. What we don't do is we don't represent clients directly or handle international cases unless there's some overlap with the UCCJEA. And we also conduct in-person telephone and webinar trainings very regularly on these interstate custody and domestic violence issues, both basic and advanced. We always list those upcoming trainings on our website. We're planning to have another basic training next week in Philadelphia and one in July in D.C. And with the exception of those two, I'd note that our trainings are generally nationally focused and don't get into the specifics of state law. But you can always call us with if you need state-specific expertise, and we're happy to connect you with attorneys in your state. With that, we'd like to kick off today's training by reading a relocation scenario for your consideration that we'll use as we go through the training. And to read it, here's Amy Lewis, our project coordinator.
Hello. So we start with Lila Smith is calling you at your office in Nashville. She's calling from her car while driving to pick up Philip Smith, her husband, from work, and only has about 5 minutes to talk. You learn in the brief conversation that Lila and Philip have been married for 5 years and have lived in Nashville throughout the marriage. They have one child, a 7-month-old daughter named Annie. Philip has physically and emotionally abused Lila since shortly after they were married. Philip has never been charged or convicted criminally for the abuse, and Lila has never sought a civil protection order against him. Lila thinks the neighbor may have heard the abuse, including the most recent incident, which took place last week. During that incident, Philip held a gun to her head in front of Annie and threatened to kill her. Lila is now telling you she wants to leave Nashville and move to Wisconsin, where her family lives and where she hopes to find a job. You invite Lila to come to your office to discuss her case.
Thank you, Amy. This is Deb speaking. Good morning, everyone. So this fact scenario is very similar to the kinds of calls that we get here daily from survivors at the LRC, and we suspect that you as advocates also encounter these types of situations. There's a survivor who has spent a significant amount of time in one state with her child, and because of the abuse wants to flee to another state where she has family, some potential support, a place to stay with the children, and a safe place to be. There are many legal issues that come up when survivors are thinking about crossing state or tribal lines with children. And today we're going to introduce you to some of these legal issues. Please feel free to contact us if you have cases like this or to give our phone number to survivors directly. But as an introduction, one of the first issues to consider is whether a particular person already has a custody order involving the children. In our fact pattern at this point, Lila has not filed for custody or for a protection order. But the reason it matters if there's a pre-existing custody order is because that can trigger several other laws. first of all, if there's a custody order in place or even just visitation for someone like Philip, Lila could be in violation of an existing court order if she leaves the state without getting that custody or visitation order modified. So there's a contempt issue. Additionally, every state has something called parental kidnapping laws. We'll talk more about that later this morning, but those are criminal laws that say if it's even legal to leave the state in the first instance with children. In some states, there may be protections around domestic violence or child abuse, things like exemptions or defenses in the law, and we'll talk with you about that a little bit later this morning. But it's always important to know when you're talking to a survivor if she's going to expose herself to criminal liability for either parental kidnapping or for child concealment if she leaves the state with the children. There are several other legal issues that are involved as well. For example, there's the idea of continuing exclusive jurisdiction. And what that means is the state that entered the custody order to begin with going to continue to have the power to make modifications to that custody order? And that answer typically is yes. The state that entered a custody order to begin with, if they had the authority to do it, is generally the state that has to modify that order. We'll talk about some exceptions to that later this morning. Another question that comes up for folks like Lila, if there's already been a custody order entered, is whether or not that's going to trigger the state's relocation law. Relocation laws typically are the state laws that say under what conditions a custodial parent may leave the state. What do they have to do before leaving the state? And often they require the parent to do things like ask permission from the court before leaving or notify the other parent before leaving. There are even a handful of states whose relocation laws are triggered in the absence of a custody order. So, for example, in Pennsylvania, even if a survivor is trying to move between counties in the state, and even if there's never been a court that's entered a custody order, the relocation law still comes into play. So as advocates, when you get these questions from survivors, you may want to familiarize yourself with these laws and also have relationships with attorneys in your jurisdiction that can give direct legal advice to survivors who wish to leave. It's almost always a better idea for a survivor to go into shelter within the state and to find a place where she has some privacy and a little bit of time and to get legal advice before leaving and moving across state lines with children. Another issue that comes up in these sorts of cases is whether or not someone in Lila's situation should file for a protection order before leaving the state. So Lila may be considering whether or not to get a protection order in Tennessee or potentially thinking about filing one when she gets to a new state, the refuge state of Wisconsin. Sarah's going to talk a little bit later this morning about the pros and cons of filing for a protection order before leaving the home state. And these can be a bit more complicated when there's an interstate issue involved, when someone is thinking about relocation. Another question that comes up is, will the survivor even be able to file for a protection order in the refuge state where she's fleeing to? And there are a couple of different legal issues that come up there. The one we've mentioned on your slide is the issue of personal jurisdiction. What that means is, does the court in the new state have the power to enter an order out over a particular party, in this case, Philip? So for Lila to go to a new state and to get the judge there to enter a protection order out over Philip, the judge will have to have personal jurisdiction over Philip. There's a concept called minimum contacts in the law that relates to personal jurisdiction, and it basically says, does this party have enough minimum contacts with the state that it's fair for the judge to get involved and enter orders over that person? So in a situation like this, in many of the interstate cases that we see, the question would be whether or not the batterer has enough contacts with the new state. in many of the cases we see, survivors are fleeing across the country to a state where they have their families of origin. If the perpetrator has never set foot in that state, it's going to be very difficult, if not impossible, for a protection order judge to enter a protection order out over the respondent. And we'll talk a little bit more about that later this morning. There also are a handful of states that go a different direction, but typically, if you're talking to survivors and they're thinking of going to a state where the perpetrator has no contact with the state, they may not be able to get the protection order in that new state. Another issue that comes up with protection order laws is that in a certain number of states, they may require that the abuse or the threats have taken place within that state in order to enter a protection order. So when you're considering advising clients or giving them information about protection order codes back in the home state, it may also be helpful to know whether the survivor will have access to even possibly filing for a protection order in the new state. Another question that sometimes comes up is, should someone like Lila file for custody in the domestic relations court in the state that she's thinking about leaving? Typically, if someone is thinking of leaving the state and that person is able to, under the parental kidnapping laws, it often would not make sense to file for custody back in the state that they're thinking of leaving. These cases can go on for quite some time, and there may be orders that are entered as part of the custody proceeding that make it more difficult to leave. Similarly, as I mentioned a few moments ago, having a custody order on the books can often trigger other state laws, like the parental kidnapping laws or the relocation laws, or this idea of continuing exclusive jurisdiction, thereby making it harder for someone in Lila's situation to leave. Another item that someone like Lila ideally would have information about before making a decision is, what are the different custody laws in the two states? So, for example, all states now consider domestic violence to one degree or another under their custody laws. But in some states, domestic violence is one out of 12 factors that a judge looks at in a best interest of the child analysis, while in other states there may be stronger protections for domestic violence survivors, something like a rebuttable presumption in the custody law that says if the judge believes there's been violence, then the perpetrator will not get custody of the child. There may be other legal issues that would make one state safer for a survivor than another. For example, some states have confidentiality laws enabling survivors to keep their exact location confidential and to use a P.O. box instead for notice of legal proceedings. So all those sorts of things, in an ideal world, the survivor would be able to know about and have legal advice about before making the decision to flee. We realize that that's not typically how these cases come about. We also want to mention that if the survivor has an issue with immigration status, that can make the decision about leaving the state even more complex. So, for example, if a survivor might be eligible for certain forms of relief under immigration laws, either filing for a self-petition under the Violence Against Women Act or possibly getting a U visa, there may be a greater need to document the history of the violence. In our fact pattern, there's been an extensive history of violence, but there's not a whole lot of involvement of the criminal justice system or the civil legal system. If it's an immigrant survivor, having that documentation can be really useful to meeting some of the standards under immigration laws that are meant to be useful and protective for domestic violence survivors. So someone like Lila may want to file for a protection order before leaving. The other issue is that it can be even more onerous for a survivor with an immigration issue if a parental kidnapping or a criminal charge is lodged against her. That can have consequences in terms of immigration status as well. We want to mention one final legal issue that comes up, and that is the standards are different in different states for issuing child support and for when someone is eligible to file for a divorce. So again, in a situation like Lila, she would have the safety and the ability to consult with an attorney before leaving the state to get a sense of how all these issues fit together, both in the state that she's leaving and potentially that attorney might want to contact a counterpart in the refuge state to which Lila is fleeing to get some answers about what the laws might be in that state. We're going to talk now about specifically the issue of filing for a protection order before leaving the state, some of the benefits and some of the consequences of doing that when there's a survivor who wishes to relocate.
So let's look first at the possible benefits of obtaining a protection order before leaving. Well, first of all, a protection order would document the violence, as Deborah suggested. That documentation will be helpful in further proceedings. For example, if Lila wants to get her case moved to a new jurisdiction, maybe to the refuge state that she's going to, or seek a custody ruling. In either of those scenarios, domestic violence can be a relevant factor for the court to consider, and having this protective order helps document it. Second, it may, of course, help protect her physically. It may be less likely that he will act out against her with that protection order in place. And what's more, it will be enforceable nationally, including wherever she moves under the Violence Against Women Act. If she's awarded custody as part of the protection order, then the abuser won't be able to follow her to the refuge state and take the children away from her. So that's a strong protection right there. And finally, for some of the reasons that Deborah mentioned, it may be her best shot at getting a protection order. The court in the state to which she flees may not have jurisdiction over Philip, that personal jurisdiction Deborah described, to issue a stay-away order. Or they may have a requirement that the violence have taken place in the refuge state. So it could be trickier getting one down the road. So given those benefits, why then should she think about holding off on getting a protective order? Well, first of all, if it's not granted, it's a little easier for Philip to deny that the violence ever took place. There may be other ways to establish this, of course, from medical or police records or witnesses. Here, Lila thinks that her neighbors may have overheard some of the abuse, but it certainly makes it trickier. Next, perhaps the biggest issue that we raise every day on these issues is that if Philip were awarded some type of custody or visitation in the protection order proceeding, it may make it more difficult or even impossible to leave the state. As Deborah mentioned, the consequences of leaving when there's a custody order already in place could include contempt charges for violating any visitation that's allowed in the order, or it could trigger state parental kidnapping or relocation statutes, as she described. And finally, if custody is issued as part of that protection order, this may give the issuing state what Deborah described as continuing exclusive jurisdiction for the duration of the protection order, which could end up forcing Lila to litigate further custody proceedings in the issuing state. She may have to do that anyway, but if the protection order establishes an even longer time frame than the 6 months she would normally have to wait, it could make things trickier for her. You see a couple more negatives on your next slide. The first is one we've talked about. It may trigger the state's parental kidnapping or relocation laws. And last is that seeking that protection order may make it more difficult to win what's called an inconvenient forum argument down the road. And Deborah's going to tell you more about that argument, but it's basically an argument that the home state that the survivor is leaving is not the court that should really take the case, that there are reasons arguing in favor of transferring the case to the refuge state. And where a court has already been involved with the case, it will have perhaps more knowledge than the court in the new state, making an inconvenient forum argument harder. And Deborah's going to tell you more about how that argument works down the road. So what are the non-legal issues that Lila needs to think about as she thinks about relocating? There are a host of safety and economic issues that ideally you would help your clients consider. And Amy's going to talk just a minute about what those issues are.
So quickly, just to kind of give an overview, anytime a survivor is fleeing, we want to take that opportunity to safety plan, or anytime you have an opportunity to connect with her, you want to take the time to consider these factors. But in particular, considering whether the refugee state is safer and what safeguards she might have once she's there. Will she have opportunity to seek shelter? Does she have job opportunities or family support? A safe place to actually live? Will she be able to get benefits or government assistance? Those types of questions that come up in terms of how will she logistically be able to survive and support herself. Also considering how responsive the legal system is, or the police and the court response, if she'd be able to obtain legal assistance in the new states based on how long she's been there. And then just considering the types of things that she would really need to take with her. Most of you are familiar with the concept of packing the bag and thinking about the important documents that she might need, particularly if she's going to engage with the legal system and try to apply for government benefits or anything like that. So just really preparing her for everything that she might need in the new state and helping her set up those logistics before, if possible, she actually flees.
Thank you, Amy. And I'm sure that you as advocates like we understand that these cases involving flight across state lines can be exceedingly dangerous. Typically, if a survivor is going to flee across state lines, that means that either she or the children are quite at risk. So we see lots of cases where the survivor knows that child sexual abuse or physical abuse is continuing to be perpetrated, or that there just aren't local resources that are helping to keep her safe within the county that she's thinking of leaving. Now we're going to turn our attention back to some of the laws involved. We have many laws with acronyms, and we'd like to just familiarize you briefly with what some of these laws are and why they're relevant to these interstate cases. So most of you have heard of VAWA, the Violence Against Women Act, and it probably funds much of the work that you're doing in your local communities. There's a small piece of VAWA called the Full Faith and Credit Provision that talks about how states have to honor and enforce protection orders that were properly entered by other states. The reason it's relevant in our interstate custody issues is because several times when VAWA was reauthorized, the language around that provision was amended slightly to make it very clear that child custody provisions within protection orders also have to be enforced across state lines. So, for example, if Lila got a protection order in Tennessee and it gave her custody of Annie, if she then went to Wisconsin, Wisconsin would have to enforce not only the no contact provisions in the protection order, but also the temporary custody provisions. That's how VAWA is relevant. The next law on your slide is the PKPA, the Parental Kidnapping Prevention Act. That is a federal law enacted in 1980, and although the words parental kidnapping are in the title of the law, it's not a federal criminal statute. Instead, it's a federal law that tells states that they have to honor and enforce custody orders that were properly entered by other states. So again, using Lila as an example, if she in Tennessee were to get custody of Annie, go through the whole process and get a custody order, and then after that point had permission to relocate and move to Wisconsin or elsewhere, a court in that new state would be obligated to enforce the custody order out of Tennessee because of this federal law, the PKPA. The next law that's listed on the slide is the Indian Child Welfare Act. One more federal law. This one was passed in 1978 with a slightly different genesis. The Indian Child Welfare Act was meant to protect Indian children from being removed from their families and then not having enough contact with tribal communities. So ICWA applies in certain types of child custody proceedings, specifically when there's a termination of parental rights issue or a pre- or post-adoptive placement, and a few other limited circumstances. It's really about when the state is intervening and removing an Indian child. In that case, ICWA gives the tribes exclusive jurisdiction to intervene in that matter. ICWA doesn't really come into play in the types of cases that we typically are discussing in our presentation. So, for example, in a custody case between two biological parents, ICWA would not apply. Or in a protection order case between two parents, ICWA would not apply. The reason we mention it in the context of interstate issues is because if it is an ICWA case, a case involving the removal of an Indian child, then that law is going to trump another law that we'll be discussing soon called the UCC-JEA. So turning to the state laws that are involved in these sorts of cases, we've mentioned several already, like the parental kidnapping laws and the relocation laws, but I'll briefly mention the others. The UCC-JA was the predecessor of the current law, the UCC-JEA. And so that was a Child Custody Jurisdiction Act. What that means is that it was a uniform code that the states started to adopt after 1968 that told judges in a particular state whether or not they were allowed to be involved in a custody issue over a particular child. The UCC-JA was helpful, but it left a number of unanswered questions. And one of the things that was happening under the old version of the law is that more than one state could legally be involved in a custody matter over the same child. So if Tennessee and Wisconsin both had the ability back in those days to be involved, they might end up entering conflicting custody orders. That is not supposed to happen anymore because of the UCC-JEA, which all states have enacted except for Massachusetts. And you'll hear quite a bit more about the UCC-JEA in a few moments. I also want to mention that there may be state and also tribal full faith and credit laws. So I mentioned a moment ago that the Violence Against Women Act has a full faith and credit provision talking about enforcement of protection orders across state lines. But there are also state and tribal laws that talk about the enforcement of this federal mandate. So typically a state full faith and credit law might talk about how the state should go about enforcing a protection order that comes from another state. Tribes are their own sovereign nations, so tribal law codes may or may not contain their own full faith and credit statutes related to protection orders or other items. The other type of law with which probably many of you are quite familiar with is the protection order laws in the various states. In your state, they may be called restraining orders or injunctions or protection from abuse orders, but these are basically civil orders that a judge can enter if there's been a finding that abuse or threats have taken place against a family member. And quite often they have a lot of tangible relief that's useful to folks in this situation. Although, as you'll see in a moment with our example from Wisconsin, they also differ quite a bit from state to state. In many states, child custody or visitation can be ordered as part of a protection order code. And that's why it's important in these interstate proceedings, because you may end up having a custody order from one state and a protection order from another state. Please do feel free to call us if you're working with survivors who have that type of issue. We can help sort out which state has the ability to enter what type of orders and which order will trump in those cases. And now we're going to get to the heart of the UCC-JEA.
So as Deborah mentioned, the UCC-JEA is the sort of current version of the uniform law that governs state courts' jurisdiction to make and modify child custody determinations. And child custody determination is defined broadly, and it basically includes custody, all sorts of custody and visitation orders, including the protection order, the emergency custody order, a longer-term custody order, the types of proceedings and orders we're talking about today. The UCCJEA was developed in '97 to eliminate the uncertainty that still arose under the previous version, the UCCJEA, regarding which state had the power to enter a child custody determination. It also brought state law into compliance with the federal law, the PKPA, the law that sets out when states must honor and enforce custody and determinations made by their sister states. And it essentially allows, the UCCJEA essentially allows only one state to assert jurisdiction over a particular custody matter with a particular child at a time. The UCCJEA also contains some other provisions that were significant improvements for domestic survivors who are moving out of state to seek a safe haven, some of which we'll talk about today. For example, it includes provisions regarding seeking emergency jurisdiction in a refuge state, and the new inconvenient forum provisions that we'll discuss, which potentially allow a survivor to get her case moved out of the state she's left. And it also specifically directs courts to decline jurisdiction over a custody matter when that jurisdiction would be based on unjustifiable conduct by one of the parents. All of the states, except for Massachusetts, have adopted their own version of the UCCJEA, and Massachusetts, as the outlier, has a version of the earlier statute, the UCCJA. So let's go back to Lila's situation, and we're going to talk about some other questions that arise out of her facts. Let's talk about first whether Lila can get a custody order in Tennessee. Or alternatively, could she get a custody order in Wisconsin if she leaves Tennessee with the children and without getting a custody order before she leaves? Third, what happens if Lila is forced to return to Tennessee to litigate the case? And finally, is it legal for Lila to even leave Tennessee in the first place with her children? What about parental kidnapping?
Great. So to start off with, can Lila get a custody order in Nashville, Tennessee? This raises the basic issue of jurisdiction. Who or what court has the power to enter a custody order out over Annie? Does Tennessee have jurisdiction over the custody case? And the short answer is yes. Tennessee has jurisdiction because Tennessee is the home state. So the UCCJEA sets up a hierarchy of jurisdictional bases, and courts have to kind of go through this ladder of jurisdictional bases to see whether or not a particular state can get involved in a particular custody case. They're laid out for you on your slide. The first is there a home state? I'll talk about that in a moment, but that's essentially probably what you're familiar with already. Has the child been in a particular state for 6 months? Next, if there is no home state, then a court considers significant connection jurisdiction. There's also a basis called more appropriate forum jurisdiction, and that allows a court in a state that has jurisdiction, like the home state, to give it up if they wish to in favor of a different forum. Finally, if there is no other option under the jurisdictional basis I've mentioned already, then any state can get involved. If it's a family that has moved around so frequently that there's no home state, there's no significant connection state, then what's sometimes called last resort or vacuum jurisdiction can be exercised and any state can be involved. But turning to the definition of home state, the home state is the state in which the child lived with a parent or a person acting as a parent for at least 6 months immediately before the commencement of a child custody proceeding. What they mean by commencement is the day when someone first files for child custody. If someone like Philip decides to file for custody after Lila leaves the state with Annie, then that state of Tennessee still gets to be the home state for a time period of 6 months after the child has left the state. As you can imagine, this poses a major difficulty for many domestic violence survivors with whom we speak and with whom you speak. So if they're fleeing for safety to a new state, they still have to be aware that the left-behind parent has a 6-month window of opportunity during which time he or she can file for custody back in the home state. And once the home state gets involved in the case, unless the home state decides to give it up, whatever happens in the home state is going to govern all over the country. So if you are working with survivors who have talked with attorneys, they know they're not going to be charged with parental kidnapping, they flee the state to live somewhere else in the country, it's extremely important because of this home state rule for the survivors to call back to the court in the county that they've left about once a week to see whether or not the perpetrator has filed for custody there. In most parts of the country, that information is accessible either online or by telephone, and it will be given out by a court to the parties. The reason it's so important to find out what's happening back in the home state is because it is going to cover the rest of the country. And also, the survivor may not know, we, as I'm sure you do, always urge survivors not to obtain their legal information from the perpetrator or the perpetrator's family. But in these sorts of situations, the perpetrator may either not tell the survivor that he's filed back in the home state for custody, or sometimes a party will say that they have filed when they really haven't. That's why it's important to get this information directly from the family court in the county that she's left. I also want to mention a couple of other important notes about the definition of home state, and that is, for children who are less than 6 months old, there's a special definition of the home state, and the law talks about it being the state in which the child lived from birth. Now, there's a fair amount of discussion in these cases over what that means. So if a child was born in one particular jurisdiction and the hospital was there, but then a couple days later the child moved right across state lines to live in a different state, which of those states is going to be the home state? If you have a client who's got a child less than 6 months old and they have questions, feel free to refer them or their attorneys to us. We do have some case law about that particular situation. We also want to mention the concept of temporary absence. So the UCC-JEA has this language that you see on your slide saying that a period of temporary absence is part of the period. What that means is that if somebody lives in a home state, like Lila lived in Tennessee, but goes somewhere else temporarily, let's say a visit to grandparents in Wisconsin for a couple of weeks during the summer, that does not mean that the home state loses its status as a home state. That's still considered to be part of the consecutive period of 6 months that someone like Lila lived in Tennessee. As you can imagine, sometimes the litigation in these cases turns on whether or not something was a temporary absence. Did they mean to relocate permanently, or were they just going for a short visit? This also comes up in military cases quite a bit, where someone is deployed to a different state. So again, if you or your clients have questions about temporary absence, feel free to give us a call directly. Moving to the next jurisdictional basis, that is significant connection. I want to reinforce that if there's a home state, a judge should not even be looking at whether or not there's a state with a significant connection. And this is a change from the old version of the law. The UCC-JA was not clear about this, but the UCC-JEA is very clear. So you only look at significant connection jurisdiction if there's no home state. So that would be a situation where a child had not lived somewhere for 6 months. Let's say that they lived in one state for 5 months and they moved to a second state and lived there for 4 months. In that situation, those states might have jurisdiction based on a significant connection with the family. It's sort of what it sounds like. Are there enough connections with that state that it makes sense for that state to get involved in the child custody issue? It also turns on whether or not there's substantial evidence about the child's care and protection and personal relationships in that state. the kinds of facts that judges are typically looking for in order to exercise significant connection jurisdiction might be something like, does the child have relationships with relatives in that state? Did they have a doctor there, or were they involved in some type of daycare program in that state? How much of a connection is there really between the family and that state? Significant connection jurisdiction is the only type of jurisdiction where it matters which parent gets to the courthouse first. As you probably understand, if there's a home state in the situation, it doesn't matter if somebody else files in the wrong state. The home state is always going to trump in terms of jurisdiction. But if there's a significant connection state, you can imagine a situation where more than one state has a significant connection to the family. In the example I mentioned, if a family is for 5 months in one state and 4 months in another state, conceivably both of those states could have a significant connection to the family. And then it does matter who files first. Once one of the parents has filed in a state that has a significant connection to the family, if the next parent, the other parent, files elsewhere, that second state is not permitted under the UCC-JEA to be involved in the child custody matter because there's already a state that's properly exercising jurisdiction. So now I want to mention some things that advocates can do to help in these sorts of situations. And one of the biggest things, of course, is to try and help a survivor you're working with to find an attorney. So many of you may already have relationships with local attorneys. If any programs receive VAWA funding to represent domestic violence survivors, that can be a good source of attorneys for these sorts of cases. And also if you just know the local legal services programs or attorneys who will handle pro bono cases through law firms, that can be helpful. Many of you already know the good-hearted practitioners in your local community who understand domestic violence issues and may be willing to take a case on a sliding scale or potentially pro bono. You can share this information with your state domestic violence coalitions or local programs in order to keep track of those attorneys. And we know, too, how difficult that can be to find attorneys to handle these cases, especially for clients who don't have an ability to pay. One of the things that we do at the LRC, if there is a jurisdictional issue, in other words, a tug of war between two states over which state can exercise jurisdiction, we will try to get involved and try to help survivors find attorneys in the state where they need representation. So you can also feel free to refer folks directly to us. Some of the other issues that you can help with are to document the abuse. Just as you would help a client prepare for a protection order proceeding, documenting the abuse can be very helpful in these interstate cases as well. As you will see shortly, there are a couple of arguments under the JEA that require judges to understand that there's been a history of domestic violence. So whether it's an emergency jurisdiction argument or an inconvenient forum argument, part of that is going to turn on whether or not the judge finds a survivor to be credible. So the same types of evidence that you might collect for a protection order proceeding, 911 calls, photographs of bruises or destroyed property, witnesses who saw or heard something, police reports, medical reports, all of that type of information can be very useful in taking advantage of these protections under the jurisdictional laws that were designed to help domestic violence survivors as well. You certainly can connect attorneys for survivors with the LRC too. We work with attorneys frequently to give them case law and sample pleadings and help them strategize. And then, of course, developing a safety plan, as we mentioned before, is always critical in these cases involving interstate flight. So now we're going to turn to question number 2, whether or not Lila could get a custody order, not in Tennessee, but if she flees to Wisconsin.
And there are really 2 parts to that question. First, can Lila get a temporary emergency custody order? And second, could she get a long-term order in the state of Wisconsin? Let's talk about temporary order first. Under the UCCJEA, courts can exercise temporary emergency jurisdiction when a child in the state has been abandoned or when emergency protection is necessary because the child or a sibling or a parent of the child is subjected to or threatened with mistreatment or abuse. And the underlying language is there to emphasize the improvement that the UCCJEA made over the previous version of the statute. Under the UCCJEA, it's enough to have abuse of the parent or a sibling, not just the child itself, in order to justify for the courts acting under emergency jurisdiction. But note that emergency custody helps only if the child is physically located with the parent in the refuge state already. So it's not going to help if the mother's trying to gain custody after crossing state lines. But even in these circumstances, attorneys and advocates often wonder whether they should encourage a survivor to file for emergency custody. And for your own knowledge, we'd recommend considering with a survivor whether the perpetrator is likely to show up and try to take the kids. If yes, generally we would advise the client to seriously consider filing in order to establish custody rights. If that risk is not great, then the survivor will also want to consider the risk that filing for emergency jurisdiction will motivate the perpetrator to initiate a custody filing back in the home state. And if she thinks she can wait out the 6 months without him filing, she might want to be able to file in the refuge state for regular long-term custody. But this is an example where of telling her whether or not to file would be legal advice, so it's best if you can connect her with an attorney to make that decision. So how long does temporary custody last? Well, what constitutes temporary custody really varies by state and with the facts of the particular case. The statute itself doesn't establish a bright line rule. We're happy to help with relevant case law should you need it. That said, the UCCJEA does say that if there's not a previous child custody determination and there isn't a proceeding already started back in the home state or the state with jurisdiction, the temporary order can remain in effect until an order is obtained from a state with longer-term jurisdiction, usually the home state. And in fact, in certain very limited circumstances, which we'll talk about in a minute, that temporary order itself could become final if there's not a filing ever made in another state. But if there has been a previous custody determination or a proceeding has been commenced in another state, any order that the judge issues has to specify the time period that the order will last. And the court does that by considering how much time the survivor needs to seek an order from the state that actually has jurisdiction. The temporary order will last only until that order is obtained or within that specified period, if it's shorter, that's set out in the order. In determining that time period, the judge is going to consider the recommendation of any judge involved in the pending long-term custody case. And that's because of the requirement for judicial communication that's in the statute. If a home state's already exercised jurisdiction and the refuge state seeks to exercise emergency jurisdiction, the UCCJEA mandates that the judges communicate. The statute requires the courts to communicate for purposes of resolving the emergency, protecting the parties and the child, and determining the duration of that custody order. So what if Lila decides that she wants to obtain a protection order in Wisconsin? In most states, this would be a way to seek emergency custody. However, Wisconsin's an exception to that rule, one of a handful of states that won't consider custody in the protection order context. So in those cases, an alternative would be to file under the emergency provisions of the state's domestic relations code. And that's what Lila would need to do if she wants to get a short-term custody order. But what if she wants to get a protection order? Maybe she wants to seek a protection order to provide protection against Philip. Perhaps she's afraid he'll follow her to Wisconsin in a violent rage after he realizes she's left. She's going to have to establish that the Wisconsin court has personal jurisdiction over Philip. Generally, courts must have both what's called personal jurisdiction, the authority over the parties involved in the case, in this case Lila and Philip, and subject matter jurisdiction, the authority to hear the specific kind of claim at issue in the case, and the authority to grant the kind of relief that the parties are requesting. Now, under the UCCJEA, courts only need to have subject matter jurisdiction over child custody determinations. So when we've been talking about which court can enter custody orders in the context of this training, we're talking about which court has subject matter jurisdiction to hear custody issues and grant custody relief. But to issue a protective order in most states, a court must have personal jurisdiction over the respondent, in this case over Philip. And Deborah gave you some basics about personal jurisdiction. That generally requires what are called minimum contacts within the state. Each state has its own laws about what those minimum contacts would need to entail, but some examples might include business contacts with the state, previous visits made there, and perhaps even phone calls or emails to the state. So what does this mean for you as an advocate? Sorry. What can advocates do to help get a temporary custody order? First, as Deborah just talked about, you can help survivors find legal representation in the way she outlined and help them navigate the legal process, since you have a better understanding than they do of how that works. And again, you can help a survivor document the previous domestic violence. And that's going to be relevant whether your client's seeking a protection order, seeking emergency custody, or even trying to get her case moved from the home state to a refuge state. Your slide provides a list of useful evidence to establish previous domestic violence. And some of these are the types of records that advocates would urge a survivor to take along if she flees across state lines, such as medical records or school records for the children. The next legal question is whether Lila can get a long-term custody order in Wisconsin. As I mentioned, there are certain limited circumstances in which that temporary emergency order can become permanent. First, if there has to be no prior custody order out of the home state and no long-term proceeding that's been commenced in any court with jurisdiction, such as the home state. Then, finally, the temporary order itself has to provide that it will become permanent in a certain amount of time when that issuing state becomes the child's new home state in 6 months. So it's not automatic. You need to make sure, or the attorney needs to make sure, that the proper language is in the order to make it permanent. And that's a great opportunity that in these particular factual circumstances to get a long-term custody order for your client. So if Lila gets a temporary order in Wisconsin and she has that language and Philip doesn't start a custody proceeding back in Tennessee, that order could become permanent. No. Could Lila file for a long-term custody in Wisconsin as soon as she gets there? First, she'd have to get Tennessee to give up jurisdiction. Remember, Tennessee's the home state for 6 months after she leaves. There are really two circumstances in which a state that otherwise has jurisdiction over a case might decline to exercise it in favor of another state, the so-called refuge state. This afternoon, we have time to tell you about one of those circumstances. Deborah will tell you about the inconvenient forum argument. If you attend one of our advanced trainings, you can hear more about the unclean hands argument.
Great. So before I do that, I just want to address one of the questions that has come up on the chat, and we'll have time for more questions shortly. So Shannon, you asked the question to be sure you were understanding the concept of home state, and you said if someone flees to a new state, is it correct that if the abuser then files back in the home state, she may be forced to go back multiple times for hearings and might even have to live there if custody is split? And let me answer that by saying possibly. So in terms of having to go back to the home state, that is going to depend on the judge in the home state. It's absolutely correct that if the abuser files, as many do, the day after the survivor leaves the state or shortly after, that the court case may go forward in the home state. It really depends on the judge in the home state. We see 3 different scenarios playing out. One of them, the worst case scenario, is the perpetrator files back in the home state and the judge immediately requires the children to be brought back to the home state. And unfortunately, that's something that a survivor would have to comply with because the home state has authority over that child. The second scenario, which can happen in many of these cases, is that the judge in the home state decides to keep the case in the home state, the custody case, but permits the survivor to continue living with the children and living freely in the refuge state. Sometimes the survivor has to come back in person for court hearings. Sometimes the survivor is permitted to participate by telephone instead and then does not have to physically come back to the home state. So that's, I would say, the majority of the cases we see fall in that middle ground. The third scenario, the best case scenario often for survivors, is that because the survivor is checking frequently with the family court, finds out that there's a case pending in the home state, gets representation, something we can help survivors do, and the attorney in the home state makes an argument, which I'm about to mention, called an inconvenient forum argument. Sometimes the judge in the home state will be willing to give the case up to the refuge state. But that decision remains with the judge in the home state. So if he or she wants to give the case up, it will happen. If they want to keep the case back in the home state, then that's what will happen. So to talk a little bit about this inconvenient forum argument, which is, again, an argument to the court that has jurisdiction. It basically is an argument saying, Judge, we know you have jurisdiction either because you're the home state or because you have a significant connection and there is no home state, but saying, Judge, even though you have jurisdiction over this court case, we would like for you to give it up in favor of a different forum, and here's why. Under the UCC-JEA, there are 8 different factors that a judge must consider when somebody broaches this topic of an inconvenient forum. The judge can actually do it even without a party or an attorney raising the issue if the judge himself or herself thinks it would be relevant. The very first factor of those 8 factors is whether or not domestic violence has occurred and is likely to continue, and which state can best protect the parties and the children. So that is one of the reasons why documentation can be so useful in these cases. In addition to being helpful for protection orders or in the underlying substantive custody case, if someone is making an inconvenient forum argument and relying on domestic violence and safety issues, evidence also is going to be important to the judge in that context. Another factor that's also coming up frequently in domestic violence cases is the fourth factor, which is the relative finances of the parties. As you well know, in these cases, there's often extreme financial control, and many survivors, if they had jobs, may be giving them up when they relocate to another state. So not having access to the family's finances, being in a difficult financial situation should be something that the judge is also considering in an inconvenient forum analysis. There are other factors as well. One of them has to do with which state is already familiar with the parties and the issues. So if there have been numerous court cases, whether it's protection orders or CPS involvement back in the home state, that might weigh in favor of the home state keeping the case. Likewise, if the survivor filed in the refuge state for a protection order and that got heard and she got a protection order successfully, that might weigh in favor of transferring the case to the refuge state. So we've mentioned a couple of cases in which judges have really found that the safety of survivors should be a priority when judges are making inconvenient forum determinations. And again, we have sample pleadings and case law for attorneys who are handling these cases. So feel free to refer folks to us. Some things that you as advocates can do on the inconvenient forum front is, again, to help with the finding of attorneys back in the home state, so this argument can even be made. If you can find out in advance what typically happens in your jurisdiction, is a survivor going to be permitted to testify by telephone? That's useful information for her to have. And even helping to find an attorney if you're an advocate in the refuge state can also be helpful, because if the survivor files for emergency jurisdiction in the refuge state, that eventually is going to trigger the requirement of judicial communication back with the judge in the home state. So having an attorney in both places is most useful. And then, of course, documenting the violence. So we're going to turn to question 3 very briefly, and then we'll take some of your questions. I know that a few of you have submitted questions already via the chat.
So briefly, what if Lila is required to return to Tennessee to litigate after having safely relocated? What can you do to help? Well, there are a few things. First, as always, we'd really want her to be represented in Tennessee, and perhaps you can help get her representation there, or your counterparts can on the Tennessee line and on the Tennessee side of the line. And again, we stand ready to provide resources and to help with referrals to help find an attorney directly if there are jurisdictional issues involved. Either way, we're happy to give you the resources we have in our database. Then, and most important, perhaps, is just helping Lila plan for her physical safety when she goes back to litigate. Can you help her find a safe place to stay in Tennessee? Can you ensure her safety when she's in the courthouse? Can you find out if there's a place in the courthouse where survivors can safely wait for their case to be called? You might suggest to her that she ask the judge for some advance time to leave before the perpetrator leaves the courtroom afterwards. And finally, the same sorts of things we've talked about in other contexts in terms of helping her gather the relevant evidence in preparation for trial.
Okay, great. So now we're going to tackle some of the questions that you've raised through the chat, and then we will open it up for additional questions probably at the end of our time today. So we had a question from John and Susan about, as a new practicing attorney, how do you reconcile working with the laws in different states? Isn't it malpractice to advise on the laws for a state where you're not barred? And that is absolutely the case. In fact, we here get questions every day about the laws in different states, and we're not able to provide legal advice except where we practice directly. So what we're advising attorneys to do is to learn about the laws in their own state and to talk with survivors about those. If you're working with a survivor who wants to relocate to a new state, you can call us and get referrals for a colleague, often an LAV grantee or somebody else who's worked on domestic violence cases before, and that person can give either you kind of the scope of what the laws are in the new state or talk directly with the survivor. So no, you should not be giving legal advice about states unless you've passed the bar there. On the question from Wendy Nelson, you had suggested that to be legally safe, if you haven't filed domestic violence charges, the best bet would be to get to shelter in the home state and then file for custody and restraining order and then file a request to move out of state. And I would say it's really difficult to generalize in these cases, and the problem with that approach is it may make it almost impossible for a survivor to move out of state. So the first question, as we laid out at the beginning, is really, are you going to violate the parental kidnapping law? If you are going to do that, then you're really forced to go this approach to stay in the home state, to see things through there, and then ask permission to relocate. But if it's a state where you're not barred by the parental kidnapping law from leaving, sometimes it may be better to leave on the early side before anything has been filed for custody. You're not necessarily going to be required to bring the children back to the home state, even if the perpetrator files within that 6-month window. A lot of this answer is going to depend on what is happening in that local area. Are judges typically permitting survivors, if there's a documented history of domestic violence, to remain safe in refuge states elsewhere? Are they permitting folks to participate by telephone? Or, the contrary, are they always ordering people to bring their children back, that might also influence your decision. Also, you had asked the question about filing for a restraining order before leaving, and that's something that we addressed a little bit earlier this afternoon, and that would depend quite a bit on all those different factors. Is that going to trigger some of the other laws that are involved? So it's tough to answer that without being very fact-specific about a particular survivor's situation and about how judges are handling things in practice. One of the things that we've noticed over the years at the LRC is that it may be a lot easier, again, if you're okay under the parental kidnapping laws, if it's a very young child, if there's not a lot of history of that child being in the state and evidence in that state. Similarly, if there's really egregious domestic violence, things like a conviction, things going on in the criminal system, judges are more likely to find that credible and may be more sympathetic about these interstate issues. We also had a question from Barbara about how would the home state work if the abuser had continuously moved and the child is under 6 months. And so with that sort of situation, it really is going to depend on the facts of a specific case. The example, Barbara, that you gave was that the child moves every month or every other month. So it may be in that sort of situation that there actually is no home state for that child. It's going to depend on the case law in the specific state where one of the parents wants to file. And we do have some case law collected, so please feel free to refer attorneys who may be handling these cases to us, or we can certainly talk with survivors. We can't give direct legal advice, but we can talk with them about these situations as well. Okay, and Amanda, I'd like to open up the lines if people would like to verbally ask some questions now. We have just a few moments, and then we're going to turn to our final topic. Amanda, I'm afraid that it's not working to do the verbal questions for some reason, so I apologize to the audience, but we'll handle a few more questions that you have submitted by chat and perhaps try again towards the end of the time.
Yeah, I think it's just unmuting that many participants. It's taking a while, and then I didn't realize it would have that screeching sound.
We have a question from Phil about the importance of about the best ways to document domestic violence, since we've mentioned the importance of helping survivors to do so. In the first instance, we were referring to the desire to ask survivors if they have made any police reports. Can they get copies of those reports before they leave the state or afterwards in the course of litigation? Do they have texts? Do they have, threatening texts? Do they have a protective order? Is certainly evidence that there's been a hearing regarding the domestic violence, and that's a way of documenting it. Medical records. Has the survivor talked to a doctor about an incident, and are there any records of that conversation, or even records of pictures of the injuries or that type of thing?
Okay, and we had a comment by Mindy about what's been going on in Maryland, and you said that things just haven't gone that well in terms of judges granting the protective parent in emergency custody, and yet you've seen many custody orders entered when the batterer has filed them. It is, we've got a ways to go in terms of family courts and these issues overall, and we see some of those same things come up based on conversations with survivors and what we're seeing in the case law. You also mentioned that judges at protective order hearings sometimes won't even talk about custody because they feel that should be dealt with in the family court later on. And it's interesting to us, we just had a training in this area. We had attorneys from across the country, and I had a small group of attorneys discussing protection orders, and they had vastly different experiences depending on what their jurisdiction was. So in some places, judges were doing just what you mentioned, and despite the ability to enter temporary custody provisions in protection orders, were not doing it. They didn't want to address it there. In other parts of the country, attorneys were saying that you could not get away with just asking for the no-contact provisions in a protective order hearing. If there was a child involved, the judge was going to be entering a custody and a visitation order, and that sometimes made things difficult if the survivor was contemplating relocating from the state. So we know that there are a lot of different experiences across the country, and we appreciate all that you're doing to educate through coordinated community response teams, different members of your community, and to highlight the importance of women being able to relocate when there's been domestic violence issues.
Mm-hmm. We had another question from Deborah about what if the domestic violence is only non-physical? How does the survivor document? And certainly we would encourage the survivor to make a record of any verbal threats that have been made, or sometimes facts surrounding the situation that make it more dangerous. For example, does the perpetrator have a gun or weapons in the house? We do often talk to survivors about keeping a log of the violence so they have sort of a record to go back on.
And just to add to that, the UCC-JEA itself does not contain an explicit definition of domestic violence, although, of course, every criminal code and every protection order code may have a definition. So sometimes the judges, when they're applying the UCC-JEA, will rely on case law or statutory definitions of domestic violence from other state laws. I want to address one more question, and then we're going to turn to our final topic of parental kidnapping. So, Dorothy, you mentioned the very complex cases that can be involved when there's either two tribal courts involved or a tribal court and a state court. And you're absolutely right. There's just a plethora of state, tribal, and federal laws that can be involved in those cases. And it can be very different because of tribal nations being sovereign nations and having their own unique child custody jurisdictional laws. It can vary quite a bit from tribe to tribe. There's also not settled case law on some very basic questions, like does the Federal Parental Kidnapping Prevention Act apply to tribes? And some of the case law that's out there says that yes, it does, and in other states they have ruled even at Supreme Court level, state Supreme Court levels, that it does not. So those cases are very different. If you have those cases and need some help, feel free to contact us and we can connect you with tribal law experts. And now we're going to turn to the issue of parental kidnapping, the state criminal laws that folks may encounter when they think about leaving a state with children.
So everything we've talked about to date, except in sort of flagging issues, are around the civil consequences of crossing state lines. But there can be criminal repercussions as well. Every state has some kind of law that says when a parent is allowed to leave a state with a child. And these laws go by a variety of different names: parental kidnapping, custodial interference, child abduction, child concealment. Advocates and attorneys need to be familiar with these laws because the consequences of leaving a child in violation of these laws can be really dire. The survivor can be subject to criminal charges and could jeopardize both her short-term and long-term custody. In the short term, even if the charge is ultimately defeated, a survivor may risk losing her kids during the process and even be incarcerated in the home state. And of course, for immigrant survivors, the consequences could be even greater. Could be a deportable offense. In some states, a parent can leave the state even if there's no custody order in place. In others, flight is criminal even in the absence of such an order. sometimes the statute is even unclear on its face. And we always tell folks that it's useful to have an understanding of how particular localities are enforcing their state laws. So what does the law look on its face, but also how is it being enforced, or is it not? What type of intent does a parent have to violate this kind of statute? It really varies by state and by statute. Usually something more than intending to cross state lines is required. And in almost all states, there are penalties associated with intentionally concealing a child from the other parent. That said, that doesn't mean your clients are without recourse if they need to protect their current address for safety reasons. There may be other pieces of state law that help. A number of states and localities have enacted laws relating to the protection of victims in domestic violence and child abuse cases, which might provide for the confidentiality of addresses and the use of P.O. Box, for example. And some states have confidentiality provisions as part of their custody or protection order statutes. And finally, the UCCJEA itself contains a model confidentiality provision for states to adopt if they don't have that provision elsewhere. So I don't want you to think you're without recourse if you're concerned about revealing your location.
Okay, so now we're going to turn to the question of what are the protections for survivors embedded within the parental kidnapping statutes. And there are protections in many states. They, of course, vary by state. And typically, they're set up in one of two ways. In some states, the minority of states, they may have something called an exemption. And what that means is that domestic violence survivors shouldn't even be charged in the first instance with a crime related to parental kidnapping or parental abduction. Other states have something called a defense, which means that probably the person is going to be charged to begin with, but may be able to assert what's called an affirmative defense at a later point in the process to make sure that there's not a conviction. In some states, the protections are laid out clearly within the state law, and others have simply been developed over time through case law. So turning back to exemptions for a moment, in a couple of states, survivors really are exempted or meant to be exempted from parental kidnapping charges. Some of the states that have exemptions, for example, would be Florida and California and perhaps a couple of others. Typically, if there's an exemption, the survivor still has to satisfy certain criteria in order to gain access to that exemption. So, for example, the way that it works in California is that a survivor, before leaving the state or within 10 days of leaving, has to file what's called a good cause report or a waiver with the child abduction unit of the local prosecutor's office or sheriff's office. Of course, the issue with this is that typically survivors who are in crisis and fleeing from the state are not necessarily going to have access to an attorney to get that information before leaving. Or in some places, advocates actually can refer folks to the good cause reports and let them know what needs to be done. The other issue in California is that there's a piece of the law that requires survivors to file within, it's been interpreted as within 30 days of leaving to file for custody. And so you can imagine how complex that gets. California is going to be the home state, but if they fled to a different part of the country, they probably don't want to file in California. They could potentially file for emergency custody in the new state, but sometimes many gatekeepers at the courts are not permitting folks to file until they've been somewhere for 6 months. Even though, as you all know after this training today, in every state you should be able to file for emergency custody without having to wait that 6-month period. So these sorts of conditions can be difficult for survivors because of not knowing about it or because the condition itself is tricky. At least previously, the exemption in Florida turned on whether or not the survivor was staying in a domestic violence shelter. And of course, for many domestic violence survivors, they may not be going into shelter before leaving the state. Turning now to the issue of defenses. Defenses are raised at a later point, and what can happen with defenses, unfortunately, is that survivors may be arrested and go to jail for a temporary period. Even if they're released while the criminal case is pending, it's likely that the children are going to be removed from them and turned back over to the batterer. So we really urge both victim advocates and family law attorneys who may not be totally aware of these criminal laws to become very familiar with them in your states and your local communities and how they're used in practice, and to work that into whatever information you're providing to survivors. I know that sometimes information that's given to survivors is, well, if there's no custody order in place, you each have an equal right to the child. Sure, it's fine for you to leave the state. But that, in many cases, is not true if there's a parental kidnapping law and if the survivor is going to be charged criminally for that down the road. Even if the criminal case goes away because of these defenses, or a defense is asserted and she defeats the charge, she may still be paying the price in the custody case. And so just to clarify, the statutory defenses, sometimes they're phrased as in flight from a pattern or incident of domestic violence. Sometimes they're phrased that the defendant was fleeing harm to herself or himself. And in the greater number of cases, there may be a child protection defense. So if you're looking up your parental kidnapping laws, the most likely defense that might exist is flight to protect children. And certainly many of these cases involve child sexual abuse or child protection issues, so that may indeed be the motivation for the survivor leaving the state. There's also a general criminal law defense called necessity. So in the handful of states where other defenses or exemptions are not available, that may be something to be asserted, but it's a very difficult standard to meet. So just to mention again the consequences, typically there may be consequences not just in the criminal system, but also in the civil case. Judges can be very punitive towards survivors who have fled with the children. They may view it as one parent trying to deprive the other parent of access to the child, or as one parent trying to go to a more sympathetic forum and forum shop because they don't like the judge that's sitting in the local community. So we have some tips for all of you to take a look at in terms of the parental kidnapping issues. You can read those on your own. But we also do want to highlight that a national sister organization, the National Clearinghouse for the Defense of Battered Women, is very, very good on these issues, works with survivors who are charged with crimes, including parental kidnapping, and can help them sort out what's happening in a case and also provide advice about defenses and exemptions to criminal defense attorneys that are involved in the case. And we have some referrals for you on the last slide as well. We're going to open it up for questions for our last 2 minutes and see if there's anything else that folks have questions about. And for those of you who may not be as focused on the chat, Amanda has mentioned a couple of ways to document non-physical abuse if there are threatening or harassing texts or other types of threats that you'd like to document in this context. Any other questions, feel free to submit them at this time in the chat. And Amanda, I'll turn it over to you to see if you want to give another effort to open up the lines or just wrap up the call.
No, I think it's just, with this many participants, it just isn't feasible. But certainly if you have any, we've got about 1 more minute. There is a SurveyMonkey link in the chat box for an evaluation. We would love to hear your feedback on today's presentation. You can also get a certificate of attendance through that if you need that to document your attendance here today. We thank Deb, Sarah, and Amy very much for their work today, and we really appreciate it.
Thank you. And we do encourage people to follow up with us if they have additional questions.
Thanks very much.